Hi there, thanks for joining us. This is Intellectual Property Essentials. My name is David Walker. We provided this webinar yesterday, and the recording was downright atrocious. So we're re-recording it so that you have hopefully an audio version that you'll actually be able to understand. I apologize for the quality. We had some technical issues with our setup here. Those are resolved now, and hopefully this one sounds and looks a whole lot better. So we're going to go through it one more time. The Shasta-Cascade Small Business Development Center is a nonprofit organization. We provide confidential, no-cost advisory and training services to small businesses. We're funded in part by the Small Business Administration and by the state of California. This is our disclaimer. It's in here because we need to let you know that this information is intended for educational and informational purposes only and does not constitute professional, financial, or legal advice. I am not an attorney, and there are attorneys out there that specialize in intellectual property. We encourage you not to make any decisions without obtaining proper financial, legal, or other professional advice specific to your situation. And the Northern California Small Business Development Center and its host, the HSU Sponsored Programs Foundation, specifically disclaims any liability, loss, or risk, personal or otherwise, which is incurred as a consequence, directly or indirectly, of the use and application of any of the information presented in this webinar. Now, a little bit about myself. I have 25 years experience in this area. I founded a couple of tech startups. I have a patent and trademark. I have negotiated over 20 intellectual property licenses. In addition to this, I've been on the intellectual property committees at the University of North Carolina and at Appalachian State University. I've been a panelist, speaker, and moderator for dozens of intellectual property related conferences over these 25 years of experience in this area. And I got to tell you, despite all of that, I do not consider myself an expert in this subject. It is simply too complex, too detailed. And so what you're going to get out of this webinar, we set some expectations right up front. This is my experience as intellectual property pertains to business and making business decisions. And that's what this webinar is about. And I hope that if you are going to decide to, say, file a patent, you contact an attorney and have them help you. This is our agenda. We're going to talk about the product life cycle. We'll talk about what intellectual property is, talk about trademarks, copyrights, patents, trade secrets, whether it makes sense to get a patent or just keep something a trade secret, some of the things you'll want to consider, how to value your IP, how to control your IP, and some other additional resources. But we'll start with the product life cycle. Now, because this is such frankly dry information, I've sprinkled some things that I found humorous or interesting, and what they are patents that have been issued and patents that have been granted over the years. There's one patent application. The rest of them are real patents that have been granted that I just thought were interesting, and I hope you find them interesting too. This first one is for animal ear protectors. And you can see it's a real patent, and that's a real drawing from that patent. So let's talk about the product life cycle and why it's important in this discussion. Every product has a life cycle, and your intellectual property is a very important part of this. This chart represents the life cycle of a very successful product. The idea is you invest money to bring the product to the market, and you're losing cash as you invested that money, but eventually sales start and you begin to recover the cash. Eventually you hit break even, and then all of a sudden your sales begin to soar because customers are beginning to demand your product. Eventually your product matures and sales begin to flatten as your product matures and becomes just part of something that people buy in their everyday lives, hopefully. Eventually, however, your sales will begin to decline as a better technology comes along and succeeds the one that you developed. And finally, people will quit buying the product as it's replaced by another technology. Here's an example of a product that went through the product lifecycle. Remember VHS tapes? There was money invested to bring those to market. They sold, they did really, really well. They matured. People bought VHS tapes left and right. They used them to watch rented movies. They used them to record movies, and then DVDs came along and sales began to decline, and people began recording their life experiences digitally. And eventually, products came along that replaced the VHS tape. So where is the VHS tape on this product life cycle? It's probably about here. That would be my guess. It's just not something that people buy that much anymore. Drones, on the other hand, may be different. A recent market study said that drone sales are expected to continue to explode through 2024. So perhaps they might be here on the product life cycle spectrum. So the bottom line with it is you need to understand where your product is on the product life cycle spectrum. How much can your product make before another technology comes and replaces it? And is it worth pursuing whatever intellectual property protection might be available to you to lengthen the product's life? Those are the key questions when it comes to the product life cycle. So let's talk about intellectual property and what it is. This is a patent that was issued for a wearable pet display. The little tubes show a little hamster or gerbil running through the little tubes, and the kid is walking around with it on his clothing. So everybody needs one of those. What is intellectual property? Intellectual property is an intangible asset that's associated with a company's innovation and know-how. And that's an important distinction because assets are usually, in the way we think about them, they're tangible, they're cash, they're inventory, they're equipment, things like this. But intellectual property is an intangible asset. The Coca-Cola brand was recently valued at over $56 billion. So it's a heavy-duty asset, but it's intangible. It's not something you can hold in your hand. It's an intangible and intellectual asset. Same with Google. Google showed over $6 billion on their balance sheet that account for intangible assets. That was in 2018. So because intellectual property is an intangible asset, we need to manage it as business people the same way we would manage our other assets, our cash, our equipment, things like that. So with that in mind, let's see if we can delve into a little bit more about the different types of intellectual property that are available. So let's talk about the 4 types of intellectual property. And before we do that, I should at least mention that I just do not understand this particular patent. A clock for keeping time at a rate other than human time with a picture of a dog checking out a wristwatch. I probably ought to read that thing and try to figure out what specifically they were going after, but well, at any rate, let's talk about 4 different types of intellectual property. First, patents. Patents are related to research, science, business, and they protect ideas or inventions basically by legally telling the world that you invented it. A patent is unique in that it informs the world of your invention. It tells everybody what your invention is and how to do it. The thing is, it allows you the right to work with that invention. And that's where the protection comes in. The issue, however, with a patent, other than simply the cost, is the fact that you do have to disclose that invention to everyone. A trade secret, on the other hand, means you don't have to disclose your invention to anybody. And that's how you protect the idea. You protect the idea and the invention by simply keeping your mouth shut, keeping the idea to yourself. Trademarks protect a word, a phrase, or a symbol to distinguish it from others. It's because of trademarks that we go and we buy a can of Coca-Cola and we drink it knowing that it's not going to be Pepsi. It's a way to protect your company's brand, logo, and identity, and this is key, to prevent confusion in the marketplace. And that's a key part there, because that is one of the biggest elements that the U.S. Patent and Trademark Office uses to determine whether they'll allow you to register your trademark federally. And we'll get into that a little bit later. Finally, there's copyrights. Copyrights protect the writing and expression of an idea, but not the idea itself. They protect original works like books, movies, drawings, manuals, websites, things like that. So let's take an example of a company that uses all four types of intellectual property and uses it to its benefit and has been doing so for several decades. We're talking about WD-40. We've all seen the can of WD-40. The old saying is that with a can of WD-40 and some duct tape, you can fix just about anything. But WD-40 is a company that uses all four types of intellectual property protection. The nozzle on the can is protected by a design patent. The shield and the WD-40 logo is protected by a registered trademark. The contents of a can are a trade secret from a formula that was developed in the 50s, and it's actually manufactured at different plants, different manufacturing plants, to maintain the trade secret. And the website, WD40.com, is copyrighted. So WD-40 is an example of a company that uses all four types of intellectual property and does so very effectively. Now let's move on to how to identify the IP that you own, while we also look at a patent that was granted in 2003 for a device to protect your banana. Nobody likes bruised bananas. And so somebody developed and patented what amounts to a banana suitcase of sorts. Your intellectual property is going to consist of your ideas, your inventions, your information, and these can be patented, or you may maintain them as a trade secret. Any secret sauces you may have, your recipes, you may protect as a trade secret. Your company and product names, your logo, your slogan and catchphrase, even your jingle, your musical jingle, if you have one, can be trademarked. You can protect those under the trademark law. Other things, white papers, websites, brochures, those can be protected using copyrights. And we'll get into each one of these so that you have an understanding of what that entails and perhaps what the value of this intellectual property might be for you. But for now, let's talk about your intellectual property strategy, some things to consider when developing a strategy to manage your intellectual property. The thing about it is, intellectual property is an asset, and it needs to be managed just like you need to manage your cash and your inventory. It needs to be managed, and so you need to have a strategy to do it. It doesn't have to be written, but it needs to be implemented for sure. And I'm getting ahead of myself because I have not shown you this patent application that was sent in 2009. It starts off by putting some ink or paint onto a substance, applying that to the nose of a dog, having the nose of the dog on a piece of paper, and you are creating dog nose art. As far as I know, this patent was not granted, which would tell me that maybe there is justice in the world after all. But your intellectual property strategy, let's get back to that. It needs to align with your business strategy. That's important because, like I said, we're talking about an asset management strategy. And so your intellectual property is an asset just like equipment, just like inventory. What your IP strategy is basically how your organization handles its IP assets. Protection. Your organization needs to protect your intellectual property. The level of protection is part of your IP strategy. How you protect it is part of your strategy. Research and development, whether or not you're going to spend more money on maintaining your competitive edge or perhaps producing new intellectual property. And then IP monetization, how you turn your intellectual property into cash. And you do that by understanding these principles of market validation, market share, higher pricing and lower costs, things like that. And we'll get into market validation and how that applies in a little bit. We'll also talk about competition in just a slide or two and how you stay ahead. The bottom line in all of this entire this entire universe of topics and things that you need to manage as part of your IP strategy. The bottom line is the benefits of your intellectual property need to outweigh the costs. If they don't, then you need to understand why you're considering protecting your intellectual property strategy to begin with. So let's talk a little bit about market validation. Your intellectual property needs to address a pain in the market. There needs to be an issue, a problem that your intellectual property addresses, and it needs to do so better than the current way that the solution or way that the problem is addressed. I have an example here of a real patent for a light bulb changer. Look at the complexity of this light bulb changer. And not understanding what this particular patent was addressing, perhaps, does it make sense considering the fact that you can change a light bulb just by grabbing it and turning it and unscrewing it? Is your solution to the pain better than what's already out there, better than the current solution? You need to understand the market opportunity, the trends in the market, the health of the industry. Is the market large enough to justify the investment? Are the customers excited and willing to change? Are the requirements for your solution really sought after by the market? And if you're going after partners to either help you bring this thing to the market or invest or whatever, are they eager to help? These are things you need to consider. And let's talk a little bit about the competition. How does the customer solve the problem today? Because that's your competition. That's the competition you really need to address. What products and processes are available? What do they use? Who are the market leaders? What is the distribution of the market share? Which market leaders have the most share of the market, and how are you going to fit in? Think about the future. Who else is working on a solution to this problem? Do a patent search from a competitive perspective and consider current research and development projects that are going on right now. Take a look at what some of the universities across the country and across the world are doing in your area and see if you can get a good estimate of about just how long you have before succeeding technology takes over your invention and your place in the market, because that's how much time you have to make up that cash that you spent and get a decent return on that investment. And then compare your technology against competitors. How long is it going to be for you to get your product to the market? How long is it going to be before your competitors come up with something to replace it? And consider the status of your intellectual property. How long can you protect it? And think about market share, because I'm going to say this throughout this presentation. You're going to hear it over and over again. What you spend on your intellectual property needs to the benefit of that needs to outweigh the cost. The benefits you get from your intellectual property need to be higher than the cost and the amount you're paying for it, or it doesn't make sense to go after it. And I'm going to throw in one more concept here, and that has to do with investors. If you're looking at investors coming into your company, some of the things they may be concerned with when it comes to intellectual property is whether or not it can be licensed. Sometimes developing intellectual property and licensing it to an existing potential competitor, to somebody who's already in the market, sometimes you might make more money doing that than you would if you tried to ramp up production or something like that. Think about existing and potential lawsuits. That's something investors are going to be concerned about. They're going to be concerned about how much longer you can maintain control and how much longer you have in that intellectual property life cycle. And they're going to be concerned about the value of the intellectual property. These are all things to consider. So that being said, let's talk about trademarks as we look at a way to play golf without using your hands. Take a look at that. A game with a telescopic putter. Okay, trademarks. Trademarks are meant to eliminate confusion in the marketplace. And by law, a trademark is automatic. If you have legally used a brand, a name, a slogan, or a sound to identify your product or service, then you have a trademark or a service mark. We're going to use those terms interchangeably. Service mark simply means that what you're offering is a service. A trademark means you're offering some kind of tangible good. So a trademark would be for some kind of product. A service mark would be if you're offering a service. United Airlines, that's an example of a service mark. They offer a service, they offer transportation. But for the sake of what we're doing here, we're going to use the term trademark to mean both. But you have automatic protection. If you're legally using a brand name that you've come up with, then you have automatic protection. You don't need to register it. You can use the TM designation to tell the world that you have a trademark. And that's that TM. You can put that on your brand now if you're using your brand legally. If you want, you can spend about $275, if I remember correctly, and register your trademark at the U.S. Patent and Trademark Office. If they approve your registration, you can begin using the designation, the R with a circle around it, which means your trademark is registered. Potentially, a trademark lasts forever, as long as you keep paying the fees. There's an initial fee about 4 to 6 years in, and there's another one about 9 years in, and then after that, it's about every 10 years. And as long as you continue to use your trademark in commerce, and as long as you pay those fees, you can go on for decades and centuries. And it's not that expensive. It's actually fairly inexpensive. We're going to talk about the different kinds of trademarks, ones that are easy to get compared to ones that are hard to get compared to ones that are impossible to get. The easiest ones to get are words that really don't mean anything. Kodak, Google, these are examples of words that are essentially made up. And they're called coined marks in the industry, the legal trademark industry, I suppose. And those are relatively easy to get. Then there's arbitrary marks that really have no that really have no meaning as it pertains to the company or the product. Apple for either Beatle music or iPods and iMacs and that sort of thing. Fruit has nothing to do with music or electronics. United Airlines, the term United doesn't have anything to do with airline transportation really per se. So these are arbitrary marks, but because they mean something, they're a little bit more difficult to get, but they still don't mean anything really when it comes right down to what the service or the product is. And as we go on, you'll see a little bit of a difference. Here's one example. Copper tone refers to something that the product does. It's suntan lotion. It helps make your skin have a copper tone, and that's the idea. Caress is a bathroom tissue, and I'm just not going to talk about that. These are called suggestive marks. They suggest what the product can do for you, and they are typically a little more difficult to get because you have to prove that you're not going to violate somebody who might be using that term in business already for their own product. And then you have descriptive marks like the old Computerland or Radio Shack. Computerland sold computers. Radio Shack sold radios and materials, electronics, things like that, that were used with radios. These are called descriptive marks, and they are probably the hardest kind of trademark to get that are allowable. And after that, the ones you can't get are things like hardware. If you have a hardware store, you can't trademark hardware store. If you have an RV park, you can't trademark RV park. Why? Because they're generic. They're generic names that have been in use forever. And so they cannot be trademarked. Here's some examples of some denied trademarks. Walmart, remember, they had that smiley face. I think they still have it. And they tried to get the smiley face trademarked, and they couldn't because it's a generic thing. Smiley faces are everywhere. Subway tried to trademark a few years ago. They tried to trademark the term footlong, but quickly found out that other food services, Blimpie and other competitors, were already using that term. And the finding of the courts was that that's a generic term, and they denied Subway the use of that term as a trademark. I've added one more. I'm saying, and this is really to protect a client. We had a client come in that had a name that they wanted to trademark. There was no other company named this in their industry that was the same name. However, that name was trademarked in a different language. And I gave an example. If the guy came in here and said the name of his company was Highest Flight School and wanted to trademark it, and there was nobody in the United States using the term Highest Flight School for a flight school. Well, it turned out somebody was using the name Zhugao, I guess that's how you pronounce it, flight school. And that term, Zhugao, means highest in Mandarin. And so the U.S. Patent and Trademark Office rejected the application because there's a large Mandarin-speaking population in the United States, and there was a chance that there could be confusion in the marketplace. Remember, I said to remember that term. In this case, they felt that among Mandarin-speaking people, that would mean confusion in the marketplace, and the trademark was denied for my client and for my hypothetical, because of my hypothetical little Zhugao and Highest Flight School thing there. Anyway. So there are some elements of trademarks that mean you need to do some research before you start going after a trademark, a registration for a trademark. Very quickly, I want to talk about genericide, which is an interesting thing having to do with trademarks. It's when a trademark or a brand name loses its identity because of use. It just keeps being used and eventually becomes generic. And the company really doesn't take any action to try to maintain the uniqueness. Some examples of victims of genericide are here. Aspirin, cellophane. Aspirin actually had a interesting history. We won't get into it, but the terms cellophane, escalator, laundromat, linoleum, thermos, these were all trademarks, brand names for companies, but became generic descriptors of the products themselves. Other products that are fighting genericide to this day are terms like Band-Aid, Chapstick, Frisbee, Google, Jumbotron, Lego, Popsicle, Taser, Xerox. The thermos was supposed to be called vacuum flask, but it lost its trademark because people kept calling vacuum flasks thermos. Tasers over here, they're fighting genericide. Their generic name, they say, is stun gun, but people call them tasers. Those are examples of genericide and how some companies are trying to fight it and trying to keep hold of that brand name. If you go to this website, which is part of the U.S. Patent and Trademark Office, you'll find some examples of sound trademarks. There's the roar of the lion from MGM. There's the tones from Intel, and a lot of other recordings. And it's kind of a fun little web page to go to play around and see some of the sound trademarks that have been registered at the U.S. Patent and Trademark Office. So let's continue. Trademark registration. If a trademark's automatic, what good is registration? As we look at a headrest for use in an area that we really don't want to talk about, a forehead support apparatus there. Well, here's an example of trademark registration. There was in the 1950s, a small hamburger joint called Burger King that did not pursue a federal trademark registration. And when Big Burger King started franchising all over the United States, all of a sudden there was a threat to Little Burger King at its headquarters there. It was a one mom and pop shop in Mattoon, Illinois, with a population of about 17,000 people. Big Burger King said they wanted to open a franchise near Little Burger King out here, and Little Burger King filed a lawsuit, said they were here first. And the judgment that came down basically said, you know what, Big Burger King, Little Burger King was there first. And so they decided that within a 20-mile radius of Little Burger King in Mattoon, Illinois, Big Burger King could not open a franchise because it would be a trademark violation. And Little Burger King's market was basically a 20-mile radius of where it was at. So to this day, you will not find a Burger King franchise within 20 miles of this Little Burger King. Now, had Little Burger King pursued a federal trademark early on, things might have turned out a little bit different. But anyway, that's one reason you might want to pursue trademark registration. Another one is the U.S. Customs and Border Control has the authority to keep products out of the country that might violate your trademark. If you notify them that you have a federally registered trademark, they have the authority to prohibit goods from coming into the country that would infringe. That's a very valuable thing and protection that you can obtain from a trademark. It gives you protection from predators. New Balance shoes are sold in China, and they filed a lawsuit against companies in China that were using their trademark on counterfeit shoes, and they won in China. New Balance won against a Chinese company in China, which is pretty interesting. They've actually done it a couple of times. They won a couple lawsuits, one in 2017 and one in 2020 against Chinese companies for using its logo. So yeah, trademarks can provide protection from predators, and they can provide a little bit of protection for your reputation. An example of that is Ben & Jerry's ice cream. Apparently, at one point in the 2010s, 2013, Ben & Jerry's filed a lawsuit against a filmmaking company that was producing a series of pornographic movies called Ben & Cherries using similar logos. And Ben & Jerry's won. The movie company settled with Ben & Jerry's. They stopped production and distribution and removed the films from sale because Ben & Jerry's wanted to make sure that none of their customers who were eating their delicious ice cream would think that they were associated with such a tawdry and terrible industry. So yeah, registering your trademark can also provide protection from abuse. Okay, so let's talk about some trademark strategies. While we look at the beerbrella, the idea of keeping your beer cool during hot weather, keep it away from the sun. That's important. So first of all, some strategies before you spend the $275 on your trademark registration. If you decide to do that, do a thorough search, but do it yourself. Attorneys will charge a fee for a trademark search, and many times the fee will be in excess of what a trademark application fee itself is going to be. Remember, we're talking $275 per class. So take a look at Google, take a look at uspto.gov, take a look at domain names. Take a look in particular at uspto.gov with the classification that you're contemplating as well. If the trademark name you want is not available, think about a different mark or communicate with the holder of that mark for permission or perhaps a license to use the mark. Some other trademark strategies, whether you have a registration or not, you start using the TM or the R if you do have a registration. Start using it now. Let would-be infringers know that you're serious about your trademark, so claim your mark now. And consider if you're selling overseas, consider the possibility of looking into an international registration. But if you do that, use a known entity. There's a lot of scams out there that will charge you a fee for registering your trademark internationally in theory, and then you find out that really all they're doing is taking your money. This is a list from the U.S. Patent and Trademark Office, the European International Trademark Office, and the World Intellectual Property Organization. It's worth reviewing those sites. Now let's talk about copyrights real quick. This is a snake leash. Everybody needs to make sure they walk their pet snake. And so this person patented a leash for his pet snake. Copyrights protect original works, books, art, music, things like that. And like trademarks, it's automatic. You have the protection there because it's original, so your original work is already protected by law, but registration is available. And if you choose to register it at the Copyright Office, it does not cost all that much. It's fairly inexpensive. Copyright requires what they call fixation, expression, and originality. The protection term is for the life of the author plus 70 years, or the shorter of 90 years of 95 years from publication, or 120 years from from creation. And like a trademark, you don't have to file for copyright protection, but it might be a good idea to do so anyway. So these are the things a copyright requires. It requires fixation, expression, because it covers the expression of the idea, not the idea itself. And it covers originality. The work needs to be original. You can't go copywriting something that you didn't write. Here are some examples of things that you can and cannot copyright. You can copyright literary works, pictures, sound recordings, architectural works. You cannot copyright ideas, common information, or names and titles, things like that. So, should you get a registration? Let's contemplate that while we look at this scratching and petting device for household pets. I'm sure your puppy or your kitty cat would be happy with something like that. Copyright registration is optional, but it is relatively inexpensive. The other day I looked it up, and a single author with the same claimant for one work not for hire is $45. If you go to that link there, copyright.gov, you can find out what the fees are. But if you're going to bring an infringement suit or bring evidence in an infringement suit, you need to have a copyright registration. The other reason you would want to get a copyright registration is because you would have the same benefit from the U.S. Customs and Border Patrol, because they can detain or seize pirated copies of protected copyright works if they know it's copyrighted, if you've registered that copyright. So those are a couple of benefits that might make it worth it for you. This is a substance dispensing headgear, and you can guess what that substance might be just by taking a look at it. But let's talk about copyright strategies. Interestingly, works for hire are not automatically owned by an employee, by the company. You should have an agreement in place that specifically states that the company owns the work created by the employee or the consultant. That's something to consider when you're considering copyrights. The other things you should consider registering perhaps would be your website, white papers, publications, and just like trademarks and just like pretty much anything else in life these days, avoid scams. Don't pay someone else to get a copyright. It's easy to do it yourself. Go to copyright.gov. They have a very easy to understand website that will walk you through the process. Now let's talk about patents as we look at this controversial animal trap from the 1880s. Patents. Patents protect inventions and ideas, and there are three main types of patents. The most common type of patent and the most complex type of patent is a utility patent. A design patent protects the ornamental look of something, and a plant patent protects plants, and we won't talk about that. That's plants, the type that grow, the type you have in your garden or your windowsill, and we're not going to get into those. Utility patents last for 20 years, design patents 14, and you get them from the U.S. Patent and Trademark Office, and they can be expensive to get. In order to patent something, there are 3 requirements. The invention needs to be useful, it needs to be novel or new, and what we mean by novel or new is it needs to be, we'll put it this way. If you wrote a paper about your invention and you published that paper a year and a half ago, it's not new, according to the U.S. Patent and Trademark Office. It cannot have been publicly disclosed within the previous 12 months. That means you didn't write about it, you didn't put it on your website, you haven't been selling it in the last 12, longer than the last 12 months. That's what novel means. And the most difficult and the most tricky one of these requirements is the idea of non-obvious. The U.S. patent describes obvious, or the non-obvious requirement as, well, they say that even though something may be a good idea and useful and new, but if it was obvious at the time the invention was made to a person having ordinary skill in the art, if it was obvious to that person, then it would not be patentable. It has to be something that somebody who had ordinary skill in that area, something that they would not have thought of, that would not have been obvious to them. That would be a requirement for a patent. There are 2 types of patent applications out there, provisional and non-provisional. A provisional application secures a filing date. It's basically a patent application that does not include everything. It includes just some very basic things. A cover sheet, a written description, a paragraph, some drawings, and a fee really is all you need for a provisional application. And if you file that, it's cheaper to file. And if you file it, you have a year to file a full patent. Full patent would be a non-provisional. It would be a patent with everything that's needed, claims and full descriptions and that sort of stuff. And during that year, if you file a provisional, you have a year to study the market, see if this is something you want to pursue, fully vet the concept. You can do whatever you want within that year, but during that year, you can tell the world that you have a patent pending. And that can be a very nice marketing tool if you think about it. You'll be able to, you don't have to tell the world, you don't have to tell people that it's a provisional patent. All you need to tell them is that the patent is pending, and a provisional patent is not reviewed by the U.S. Patent and Trademark Office. They don't look at it. They'll look at the non-provisional. They'll look at your full patent application, but they won't look at a provisional one. So that's something to keep in mind. It could be useful, if nothing else, as a marketing tool. I know some people that will file a provisional, and towards the end of that year when it comes up, they'll file another provisional. And they can continue to say that it's patent pending for a couple of years. However, if when they file the non-provisional, when they file the full patent, they will not get, they'll get the date of the last provisional. They're not going to get a date of a provisional that was filed 2 years ago. The provisionals expire after a year. So let's talk a little bit about patent strategies as we look at this patent, which is a method for carrying a child. Utility patent considerations. They are high cost. They cost a lot of money. And you need to think about the likelihood of succeeding technologies. Where are you at in the product life cycle? Where are your competitors? What advances are being made, and do you expect them do you expect to be made that will replace your invention, and when will those come about? And are you going to be willing to defend a patent? If you find somebody who's infringing, is it worth the money to you to defend the patent, to go through the headache and the cost, maybe spend $100,000 defending a patent in court? Is that going to be worth it? Because if it's not, it may not make sense to get the patent in the first place. Let's take a look at some utility patent costs. These were put together a year or two ago by some interns that we hired. And as you can see, patent costs, utility patent costs vary widely. You can find similar numbers to these on the internet as well, but basically including attorney's fees and filing fees, it can be anywhere from about $7,000 to over 20 grand. And it obviously depends on complexity. It also depends on how many times you go back and forth with the examiner, and how and what kind of changes need to be made by during that process by the attorney. So there's a lot of variations, and but what you can see from this though is that utility patents are expensive. Let's switch a little bit to design patents, because design patents are not as expensive as utility patents. Here's an example of a design patent, 3 pages long and basically 5 drawings of a thing that is being patented. Because a design patent, remember, it covers the ornamental look of something. In this case, this is the look of an RFID tag that was developed. This patent was issued in 2014. It was originally filed in 2012, but this design patent covers the look of this device. And let's go back, because really the cost of this patent is low. It's just a couple $300 or so for the filing fee with the U.S. Patent and Trademark Office. The real cost is in getting a professional to do the drawings for you so that they conform to the requirements of the U.S. Patent and Trademark Office. But you can get it done through LegalZoom. It would cost maybe, I don't want to quote them exactly, but $1,000, $1,500 maybe, and you have a patent at the end of the day. And there's market value because you file that and you're able to say patent pending, and after the patent is issued, you can say that it is patented. You don't have to say whether it's a utility patent or a design patent. There's nothing compelling you to do that in your advertising material, but at least you can have a prestige factor. You can have, perhaps there may be some competitive suppression that you can do by protecting the ornamental look of your product. There may be some value there. So it's not something to just ignore right out of the box simply because it's only protects something from an ornamental aspect. There may be some value to having a design patent. Provisional patent applications also are relatively low cost, and they're a placeholder that you can use while research into the markets or into the some engineering and technical aspects of your invention continue. There is some market value, perhaps, to a provisional application, to being able to say patent pending, and it is possible that you could use the designation as patent pending to get a head start in the market and to suppress competition as well. There are ways you can do these things. And as we said with everything else, there are patent scams. There are a lot of solicitations that you'll get once you file your patent application. You'll get patent scams from the U.S. From a lot of unsavory people. Take a look at this link on scam prevention from the U.S. Patent and Trademark Office. It's important. Now let's talk about trade secrets as we look at a fresh air breathing device and method. That isn't necessarily as disgusting as it looks there. The idea is that if there's a fire going on in the house or whatever, that there is fresh air available in the trap here. It may not be the best spelling thing, but it's available, and this is a way to access it. That's what that patent's all about. Let's not look at it anymore. Trade secrets basically protect information. For example, the WD-40 formula, Coca-Cola's formula, KFC's herbs and spices. You can govern these to a degree through the use of a non-disclosure agreement or an employment agreement where anybody that has access to these trade secrets agree not in writing with penalties attached, agree not to disclose those secrets. There's obviously no government registration required, and they potentially last forever. They last as long as you can enforce the agreement, I suppose. And obviously they're inexpensive. The cost of protecting it is going to be limited to the cost of getting a non-disclosure agreement or some other agreement in place, and the cost of whatever apparatus you might want to employ to keep that secret. WD-40 does it by having the some of the ingredients prepared at different places. So trade secrets can be relatively inexpensive. Some examples of trade secrets include, as we said, Coca-Cola's formula, WD-40, the baseball's rubbing mud, which I'm told comes from the Delaware River. I don't know why that's a trade secret, but a lot of people list it. So, okay, there you go. Google's algorithm is a trade secret. It changes as they improve things. New York Times bestseller lists, the way they choose their bestsellers. There's a lot of trade secrets that are used in commerce. And there are advantages, obviously. Low cost, there's no expiration until somebody opens their mouth. They can be used as an effective marketing tool. KFC back in the day, the Colonel talked about his secret herbs and spices. And so, it can be used as a marketing tool. And there's obviously no disclosure required. Disadvantages, it can be circumvented by a slip of the tongue. Your enforcement options are limited pretty much to whatever you can agree to in your employment agreements or NDAs. And if they're stolen, there's a possibility, a slim one, but depending on circumstances, they could be acquired by others and patented by others under some really unique conditions. So there are advantages and disadvantages to trade secrets. So which one should you do as we look at a combination wing and blimp flying machine from 1889? Well, let's take a look at some things to consider when you're trying to decide whether you should patent something or keep it as a trade secret, assuming that the item is patentable. Are you willing to spend the money to defend a patent? If so, maybe it makes sense. If you can't even afford name brand cola, then maybe a trade secret might be best for you. How easy is it to reverse engineer the idea? If it's easy to reverse engineer it, you may need a patent to protect it. If it's difficult, a trade secret might be adequate. How likely are you going to detect infringement? If you don't know the infringement is going on and somebody is able to take advantage of that, why bother patenting the thing? So that's another thing that you might consider when trying to decide whether to patent something or keep it a trade secret. So should you get a patent? Well, first, make sure that you want the patent for the purpose of competitive advantage. There's no reason to get a patent for prestige. There needs to be some kind of real advantage. You need to understand the addressable market that you're talking about, the number of people you can realistically sell to, so you can figure out if there's enough of a market to justify the expenditure. And how long do you have? How long will it be before a successor technology takes its place? And can you make enough money in that time period to more than make up for the costs of the patent and your return on investment of that cost? And will you spend the money to defend it? Can you make enough money to justify defending the technology in court if you need to? Let's talk about valuation of your intellectual property as we look at an invention for a self-inspection apparatus. How do you determine the value of your company's intellectual property? Well, we'll talk about four approaches that are commonplace. First is generally accepted accounting principles. Then there's the market approach, the cost approach, the income approach. But when it comes right down to it, it's a negotiation. Let's go through these. And quite frankly, I'm not sure if I have these in the order I have them here, but we'll talk about generally accepted accounting principles first. From an accounting perspective, your intellectual property is an intangible asset. And according to GAAP, accounting principles, what you do is you take the amount that you spent for the patent, how much you paid to get it, including attorney's fees, and you amortize it over the useful lifespan. And that's really the value of the patent from an accountant's perspective. However, in the market, things might be quite a bit different. You can value your patent in the marketplace from the income approach, which basically means you calculate the value of the patent, how much net profits you'll make, market share, lower costs, whatever the value of that intellectual property is, you estimate a financial model over the life of that intellectual property and how much you'll be able to, how much value you will see from that intellectual property in actual profits, lower costs, cost savings, whatever, and then calculate the net present value of that by applying a discount rate, which is the weighted average cost of capital, and adjust for risks. You can find all of this. If this is Greek to you, there are articles on the internet where it explains it, or you can contact your SBDC. We can walk you through it to a degree, and help you make a fairly decent stab at an income approach. The market approach uses comparatives. It's similar to buying a house. With the market approach, you look at similar technologies, similar intellectual property that has sold, and how much did it sell for under those circumstances. And that actually is a good way to validate a figure that you may have gotten from the income approach. You can find these figures on SEC filings sometimes. There are reports that cost money, but they're out there, that list these kinds of transactions that have happened. And so they can give you an idea of similar comparative deals that have been made for intellectual property similar to yours. And there's the cost approach. The cost of someone duplicating or competing with your technology. How much would it cost for your competitor to catch up? How much is it going to cost him or her to prepare something that can evenly compete with your technology? And that would equate the value of your intellectual property. But what it's going to come down to at the end of the day is a negotiation. At the end of the day, if you are trying to sell your technology to someone else, you're going to say it's worth $10 million. They're going to say it's worth $1 million, and then you're going to negotiate and come up with a price. So let's talk briefly about the control of your intellectual property as we look at this guy who is working with leaf gathering trousers, which is an interesting idea. Generally speaking, my personal opinion is that if there are registrations to be had, it usually makes sense to go get them, because in addition to protection, they can provide some level of validation and help in your marketing. It helps make people feel that what you have is real, that you're not just a fly-by-night outfit. You have valuable intellectual property. Relationships with the inventors of your intellectual property are important. I have an example here. Back in the mid-90s, I was involved with a company that licensed a gas sensor from a national lab. And we maintained the relationship with that, with the inventor of that technology. And as that national lab improved the technology, we received the benefit of those improvements. We maintained the relationship, and we were there to make the improvements that were necessary over time. The technology is now owned by another company, but they continue with that relationship. And as advances are made, they incorporate those advances because they've had, and they do it with a very nice deal structure that they have with the national lab, because they have a good relationship with them, a nice, successful, mutually beneficial relationship. So it's important to maintain that. If you're going to consider licensing, there are some things that you're going to want to consider as well. And this is a whole new webinar in and of itself, because licensing, there's a lot of factors that you might want to think about if you're going to consider licensing your intellectual property to another entity. You're going to want to consider term length, exclusivity, geographic rights, marketing rights, the fees, royalties, maintenance fees, who's going to pay for patent maintenance, things like that. And that's really a whole workshop in and of itself, but it's something you'll need to consider when you think about these things. And finally, is there anybody else out there who has a possible claim? One of the more famous incidents of a third-party claim happened in the 70s when George Harrison released the song My Sweet Lord, which was a very successful song, but it just happened to have an identical tune to He's So Fine, which the Chiffons recorded about 10 years prior. And eventually there was a settlement on that issue, but it cost money because there was an infringement on that intellectual property, even though they determined that the infringement was an unconscious one. At any rate, something else to look at. Does anybody else have a claim to this idea? And if so, address those issues before you spend the money to go to market. So let's look at some things to consider and some self-assessment questions as we look at a device that is used for waking persons from sleep. It looks like a dangerous thing to me. But some things to consider. What will the intellectual property do for your business? Is there a competitive advantage? Does it help with market entry? What is the investment? Is it worth the cost? Think about the market, the industry, risk analysis, the potential return on investment. And if you're bringing in investors, venture-backed firms are much more likely to hold patents regardless of the technology focus. The reasons that they're going to be looking for, they're wanting to have security for the investment. They want to increase the odds and the quality of a liquidity event. They're going to want to have a strategic role in negotiation and defending the patents against infringements, and they may want to develop a brand of technology leadership. All of these reasons are reasons that investors may want you to pursue some level of intellectual property protection, and that's something else to consider. Here's an interesting fact as well. Another interesting thing to consider. Bill Gates once said that intellectual property has a shelf life of a banana. And I have an illustration on that. This device that you see here is an RFID tag. It produces a radio wave that can be read from many, many feet away. So the idea is you put this little tag, which is maybe 2 or 3 inches long and just an inch wide, something like that. And you attach that tag to a very expensive piece of equipment. And then from 100 feet away, 150 feet away, you have a device that emits a radio signal. And this tag that you see on the screen will detect that signal and send a signal back with a code that is unique to that thing that it's attached to. So if you want to know, hey, where's the Xerox copier that's supposed to be out here in this huge warehouse, and you make sure it's there by using this this device and this methodology. It's called an RFID tag. They're used, and they exploded in use in the market in recent years. They're used everywhere. Well, about 8 or 10 years ago, we entered the market with the one that you see pictured there. This was a unique RFID tag because it had a solar panel that charged an ultra capacitor here. So it boosted the signal of this tag to something that was significantly better than what was available in the market at the time. And it did great for about 1.5 years. And then competitors came along and beat us in price, beat us in performance, and we just couldn't compete. To give you an idea, we sold these for about $3.50 a piece. Today, you can buy a stick-on version of that in a roll of about 20,000 of them for about 16 cents. That's how fast intellectual property comes and goes. Bill Gates was right when he said that intellectual property has a shelf life of a banana. A lot of it really does. So when you make a decision about whether to get a patent, there are a lot of things you have to consider. And these are some of them. The product life cycle, the time to market, how much it's going to cost you to get the patent, how much it's going to cost you to defend it, where things are now in terms of intellectual property and in terms of your competition, whether you're going to have investor interest, and what the value of your intellectual property is going to be when you're ready to cash out. So things to consider when making the decision. And I know I'm saying the same things over again, but it's really important. Do you have an idea worth protecting? If you do, have you obtained legal counsel? Do not try to patent something yourself. That's just a bad idea. And from what I've seen, my experience, my opinion, if you have something that you can patent, get a patent agent, get a patent attorney, hire somebody who knows what they're doing to do it for you. Because believe me, if you try to do it yourself, chances are all you're going to be doing is wasting money. Have you completed a cost-benefit analysis? Are you basing your company's future on a patent? You don't want to have necessarily a one-trick pony if you don't have to. And have you assessed ways to leverage your intellectual property? So let's talk about some additional resources. Oh, wait a minute. I didn't take a look at the gravity-powered shoe air conditioner. If your feet get sweaty and hot, this sucker will keep them cool. So there you go. That's nice. Additional resources. Take a look at the USPTO.gov, U.S. Patent and Trademark Office, the copyright.gov, that's the Copyright Office. The SBDC has a tech futures group. You can contact them through your local SBDC in Northern California. This is where we're at in Northern California. We have a tech futures group, and we can put you in contact with them. And the SBTDC in North Carolina has created an intellectual property guide. I'm very, very familiar with this guide, and I would strongly urge you, if you want to read more on all of this good information, download that guide. It's free. Go to SBTDC, Small Business Technology and Development Center, sbtdc.org, and you can navigate to resources, publications, and you'll see the intellectual property guide there, and you can download the PDF for free. That's it. That's what I got. Nobody's listening to this for final questions. So the next steps, as we look at the final patent drawing for a motorized ice cream cone, which is just a terrific idea, if you ask me, your next steps, contact us. This is Emily's email address. This is my email address. This is our website, sbdcsc.org. The Tech Futures Group website's here. If you're not in Shasta or Trinity counties in Northern California, you can find your local SBDC by Googling it or by going to America's SBDC.org/find-your-SBDC. That's what I got. Thank you so much for listening. Again, I apologize for the quality of the audio at first. Hopefully this is better. Take care.